Night is brought to you by
Flamingo Paint. Superior durability, superior hiding, superior coverage, simply superior.
Sasso insecticide spray and coil.
Hello and good evening to you. Welcome. This is Ghana Tonight. We're live from Anisha Desawe Kanda, also live on TV3, Ghana on Facebook and on DSTV channel 279. We're all across the world on 3news.com. I am Alfred Okanse. Tonight, the Attorney General, Dr. Dominic Akurechinge Ayene, defends the sanctity of the Operation Recover All Loot and fends off allegations of deals cutting. Stay with us. This is not the first time he's had cause to as it were, respond to this matter. We'll get into it tonight. Also, reduction of Nana Agrada's jail term from 15 years to 12 months stirs public curiosity about how the criminal justice system works. We have some legal education for you, so stay with us. And as to whether there's also an opportunity for an appeal of that particular sentence if the state is minded. We'll get into it. Also, sharp decline in inflation splits views of members of parliament over the performance of the economy. This was topical on the floor of the House earlier today. Stay with us. We'll get into all of that. As always, you're an integral part of the conversation. Let's hear from you. The hashtag that we're using is Ghana Tonight on Facebook and on X. Let's get the conversation going. Let's settle for Ghana Briefs.
The Attorney General and Minister for Justice, Dr. Dominic Ayeni, has dismissed accusations that his office is cutting deals or entering into plea arrangements in cases being prosecuted under the Operation Recover All Loot initiative. Addressing the issue during a working visit by Vice President Professor Jane Nana Opoku-Agyeman on Thursday, Dr. Ayeni assured the public that prosecutions under oral are progressing steadily and transparently.
Accusations being raised about the fact that we are cutting deals in the oral cases. Your Excellency, oral is going very, very well. However, I want to put it on record, and the National Intelligence Bureau will bear me out. No docket has come here that has been compromised in any way. No deal, no plea arrangement has been entered into with anybody who has committed an offense.
President John Dramani Mahama has cautioned that Africa is currently battling a pandemic of unfulfilled potential. Addressing the Zambia legislature as part of his 3-day state visit, the president regrets that African nations remain shackled by what he describes as triple dependency condition, undermining the sovereignty won by Africa's forefathers.
Africa needs and deserves transparent and accountable leadership. The institutions and the laws to fight corruption must be allowed to operate without fear or favor. Abuse of public trust must be punished. We must protect public resources and use them efficiently for the good of our people. The improved performance of the Zambian currency, the kwacha, and the ongoing reform agenda sends positive signals to investors and regional partners.
The minority has opposed the proposed legislation seeking to establish an authority to oversee the 24-hour economy policy, saying the bill duplicates the functions of existing institutions and fails to adequately address the unemployment challenges it is intended to resolve. Majority members dismissed the claims and defended the proposed legislation during a heated debate on the floor of Parliament.
You thought that 24-hour economy was going to be your Ghana Beyond Aid. That never had a policy. You thought that 24-hour economy was going to be like your free senior high school. That never had a policy. You are trying to think that 24-hour economy was going to operate like your one district, one factory. That never had a policy. Your digitalization, that never had a policy. Today, we are walking the talk.
NPP Ashanti Regional Chairman Bernard Boisiaku Entry, also known as Wontumi, says he has received the blessing of leading members of the party and Council of Elders to vie for the national chairman position. He believes the time has come for an individual who has the capacity to mobilize the grassroots and every hierarchy within the new patriotic party to take the helm to wrestle power from the NDC in 2028.
We need a mobilizer, the chairman mobilizer, the chairman who can use a research. You know, a lot of people call me as a science and data. I have a group, you know, as a movement group, you know, a political movement group, to use science and data to base on the researches.
There will be no burials at the Osu Cemetery for at least the next 2 months. The Tamakloe Municipal Assembly says the decision follows disturbing reports of illegal grave installations, grave looting, and the unauthorized sale of burial spaces. Alfred Alote Gazi is the MCE for Tamakloe Municipal Assembly.
In the interest of protecting public trust and restoring order, the Tamakloe Municipal Assembly wishes to announce the following immediate measures. 1. Suspension of burials. All burials at the Osu Cemetery will be put on hold in the next 2 months. This suspension applies to the general public. However, burial for indigents will be permitted under strictly controlled procedure.
And you're still live here on Ghana Tonight. There's more news on 3news.com. Make some time and visit 3news.com. This is Ghana Tonight. We're live on 3FM 92.7, also on TV3 Ghana on Facebook and on DSTV channel 279, all across the world on 3news.com. So it's probably brought to you by Flamingo Paint, Simply Superior, Sasso Insecticide Spray and Call, Kumtumtum Preko. Coming up next year on Ghana Tonight, the Attorney General has continuously shut down this deal-cutting allegations and assures transparency in the oral prosecutions. On this matter, this is not the first time this is coming up for the Attorney General to respond to. As a matter of fact, to the extent that there's some still brewing in terms of conversations about this particular allegation that was put out by no meaner person than the General Secretary of the ruling NDC, Fifi Avikwete, sometime last year. But today, the Attorney General and Minister for Justice, Dr. Dominic Ayeni, has once again dismissed claims that his office is cutting deals or entering plea arrangements in cases being prosecuted under the Operation Recover or Loot, that's oral initiative, or the flagship of this administration. Now, speaking during a working visit by the Vice President, Professor Jaina Opoku-Agyemang, earlier today, Dr. Ayeni assured the public that prosecutions under oral are proceeding steadily and transparently. Take a look.
Accusations being raised about the fact that we are cutting deals in the oral cases. Your Excellency, oral is going very, very well. However, I want to put it on record, and the National Intelligence Bureau will bear me out. no docket has come here that has been compromised in any way. No deal, no plea arrangement has been entered into with anybody who has committed an offense that comes within the ambit of the oral briefs that we have received from the NIB and are prosecuting. We have 16 dockets under review, and then we will be putting those ones through the process of critical scrutiny, so that when we notice that there are loopholes in the investigations, we'll tell the investigative authorities to bring us more evidence, as we are doing now with the National Service prosecution. So I want to assure the Ghanaian public, using this platform, that we have not entered into any plea negotiations with anybody that committed an offense that comes within the remit of oral.
But you see, just for the uninitiated, why is the Attorney General saying this? Let's recall exactly the allegation that Fifi Fiavikwete, the General Secretary of the ruling NDC, put out sometime last year during the NDC legal team's meeting in the Ashanti region. Take a look.
If it's to be done, it must be done well. And to be done well means it has to be thoroughly done, proper due diligence. The job must be properly done. And you are the lawyers, so you should know. If you say righteousness and justice should be the foundation, it must be. So you cannot in one breath be making proclamations that are condemning those who are on the other side, while you yourself are part of the system that wants to subvert the same laws and the same constitution, the same rights things from being done. So you should be the first point of making sure things are done properly. That's the only way we can establish a society that will be truly great and strong. My first point. My second is this. And Attorney General, I'm sure the pressure is mounting. We at the level of the party are picking the signals. And the signals we are picking is this: that many among us, in spite of the fact that pleas and the pressure coming from the public that things have to be done properly, punishment must be exacted, and things have to be done, some among us are busy trying to cut deals with people who are supposed to be prosecuted. Some among us are trying to cut deals. Some are becoming conduits through whom pressure is being brought to bear on people who are supposed to do what is right. I'm not mentioning names. A time may come where we may have to. A word to the wise. Some know themselves, those who are. We are hearing your names. Think again. Because this victory was achieved largely because the people of Ghana wanted the right things done. Not for deals to be cut. For them to say, okay, now that we are on the other side, we cut deals so that tomorrow you also can get a deal cut. No, it won't happen.
Well, so that's Fifi Kwete there. Very strong in his words and the passion with which he speaks about this. And in fact, a few days after he made this statement last year, the Attorney General responded. And then he's had cause to say it again, the second time, this time in the presence of the Vice President. And Adam Senano is the co-chair of the Citizens Movement Against Corruption, joining us on Zoom right. Senano, thank you for connecting with us here on Ghana Tonight. I know you're still in Chad, doing your duties with the African Union, but I appreciate you that you stayed up to connect with us. But first off, to the extent that this is not the first time that the Attorney General is having cause to respond to this, the second time, and then the reassurance that is coming in consistently, how does it get to you?
No, I don't think so. I mean, if something happens once, you say it's happenstance. But when it repeats itself, then there's a pattern. And the caliber of the person who is raising this issue. I think the first time I heard it was the General Secretary sometime last year, and it's been repeated. I can't imagine why the General Secretary of a party as big as the NDC would repeat this statement if there wasn't some red flag, there's smoke, yes, but there must be some kind of fire. So in my view, rather than sweep it under the carpet, it probably suggests that the Minister of Justice is a high-ranking official. He may not know all that is happening under his watch, and perhaps he himself ought to scrutinize what is going on and maybe engage the General Secretary. Why do you keep repeating this? So I don't think that one should be quick to be dismissive of what the General Secretary has said.
I see, but the earlier posturing was that assurance that he gave in responding to the concerns in this particular statement that the General Secretary made last year. In fact, when the President met journalists last year, I put the same question to the President as to whether he had heard Fifi Kwete's allegation and whether he, as a chief oral to a campaigner, was concerned about it. And he had indicated at the time, at that press conference with the journalists, that he wanted to call Fifi Kwete to come and answer for himself, as it were, tell all of us on national television the evidence that he has. But Fifi Kwete, if you hear him in that tape we just played, said at that time he was not going to mention names. But when the time is right and it is necessary, names will be mentioned. I mean, if you're talking about the Attorney General having some sort of engagement with him to understand why he's saying so, probably there's something that has slipped through. In what form should this engagement come, especially taking into consideration what the President said last year?
Well, I think that the President's position is clear. He has consistently said he will not countenance any actions, any corruption, anything that undermines the good name of his government. That's consistent. But it does not take away the fact that, we are, to some extent, a close-knit society. The networking behind the scenes is a lot. So A hears something, B gets to know about it, information flows. It would seem to me very strange that the General Secretary of the party making these comments without any basis. I mean, that is very, in my view, very unlikely. There must be something he has heard, something that has happened, and to repeat it. Perhaps he's trying to say, Mr. President, if you like, bring me before the cameras. And that might not be the political action to take. That might not be too politically, I don't know how to put it, correct. So I think that they better engage him rather than be dismissive. It also shows that there is some level of internal democracy. He's not being muzzled. He doesn't feel so constrained that he cannot speak publicly.
But this
we
comes
did maybe in the first instance.
Right, but this comes at a time when the Attorney General, for the second time, has had to put out this statement of reassurance, even though this has not come up again after Fifi Kwete said it sometime last year, and the Attorney General responded to it. But in the presence of the Vice President, he's had to re-echo this to send that clear signal that there's really no root and there's no reason to, as it were, suspect that there's something nefarious happening in this whole fight in the oral. But if you're talking about some form of engagement going forward, now how, and that's what I was talking about earlier, about the form of the engagement, especially because, as we speak, the Attorney General has been clear. Nothing is happening. That's in his own words.
I mean, one of the things that, we have this formula we use when I'm doing leadership training. We say effective leadership is a function of LEF. So capital E equals L, small e, small f, where L is the leader who listens, E is the leader who has experience and exposure, and F is the leader who has followers who give critical input and ask critical questions. it's always good to listen. Listen to the more informed we are, likely to take actions that benefit the collective much more than you would have done if you didn't. So my view would just be, look, no matter who is speaking, let's not say or if we can't do that, we have persons who can do some background checks for us. We probably should do that. Otherwise, when we talk about effective leadership being a function, that's capital E, a function of LEF, where L is the leader who listens, E is the leader who has experience and exposure, and F is the leader who surrounds himself with followers who give critical input, ask critical questions. And exposure usually would select leaders who have experience and exposure. And the F is also make sure you surround yourself with not just the bootlickers, but also those, because often they give you a perspective than you would have if you didn't pay attention to the critiques as well. My leaders, not just our
right. Zano, I think that your point is clearly
especially when
made.
It's come from your own party.
Great.
Perhaps.
Yes, your point is clearly made. I apologize to our viewers for the cranky nature of the connection to Adam Senano. Got bad at the end of this conversation. But Senano, thank you. Your point is clearly made. He is the co-chair of the Citizens Movement Against Corruption, and he is in charge right now. Probably that explains the poor connection that we're having, but he is in charge performing his duties as the chairperson of the African Union Advisory Board Against Corruption. So thank you, Zeno. Thank you for joining us here on Ghana Tonight. But coming up next here on Ghana Tonight, we deal with matters of the courts. And earlier today, a lot of you have been talking about what happened earlier today. Agradaa is in the news again, and for the obvious reasons. The jail term has been reduced from 15 years to 1 year, raising eyebrows. Now, we're going to break it all down to you as to exactly what all of this means, and then we'll have a private legal practitioner also join us to help us put the matters in context and in perspective, because, monitoring the conversation and then also the reactions to this particular outcome in the court of law today, we need to understand what exactly happened. Now, the huge sign of relief for what is the person who has been described as a repented former fetish priestess turned evangelist, Patricia Esiedua, known in public circles as Nana Agradaa, after the High Court in Amasaman reduced her 15-year jail term to 12 months. Now, the Trial Circuit Court had convicted her for defrauding by false pretenses and charlatanic advertising. Now, all of this has its roots in law when it comes to the jail term or how many years sentencing is applied to such offenses. Well, the decision has, however, generated a lot of conversation and confusion, for that matter, in the minds of many as to what exactly the position of the law really is. How did the court arrive at this particular outcome? And that is what has got a number of you talking as we speak, and what the way forward should be, and whether or not the state is going to seek any form of appeal, or this matter is effectively ended. Well, we got the full reasoning of this particular judgment, the ruling of the trial judge on this particular case. We've got the full ruling. If you have the full complement of it, you go on 3news.com, you'll find it. And my colleague Dennis Paberi Wadam Esquire, going through the entire full ruling, teased out a few things that are sticky points, which we're going to be getting into. It gives us a clear idea of how the way forward will be. But bear in mind, Agradaa has been in for almost 7 months now. So what that effectively means is we're going to be finding out whether then the 7 months would be taken out of this 12 months, then effectively in the next 3 to 5 months, she should be out. And we'll get all of that clarity. So it's not a 1 year out of the 7 months, or excluding the 7 months that she's been on or in already. But this is it. This is where the real meat of the matter is in the full judgment. In the light of the foregoing, and I'm going to put on the screen right now, having taken, and this is the trial judge in the full reasoning of why the decision was taken to reduce the sentencing from 15 to 1 year, it made the following considerations: that the victims of the offense of this charlatanic advertising and defrauding by false pretenses, for which Agradaa, and remember, Agradaa was appealing this ruling. So this is at the appeals court. The appellant was convicted and sentenced to 15 years. Were only 2 in number. The victims were only 2. And the amount involved was also 1,000 Ghana cedis. That's number 1. 2, that the appellant Agradaa has been ordered to refund the amount involved, that's the 1,000, to the victims of her crime. 3, that there is no defined minimum sentence of imprisonment imposed by law for this particular offense. That is what we want to find out. The trial judge says there is no defined minimum sentence of imprisonment imposed by law for this particular offense. But we're going to show you what exactly the law says about the sentencing when it comes to defrauding by false pretenses especially, and also how many years any person who has been convicted by such a crime would have to be in. Also, the trial judge says the trial circuit court failed and or refused to make the 32 days the appellant had already spent in custody count. That in the opinion of the trial judge, the sentence of 15 years imprisonment was meant to serve as a deterrence. A view says he subscribes to. I hereby, quote, reduce the sentence of 15 years imprisonment in hard labor imposed on Agradaa by the trial circuit court, and rather sentence the appellant in the following manner. I affirm the appellant's sentence of 25 penalty units on count 1, that is the charlatanic advertising, or in default of her payment of this fine, the appellant is to serve an additional term of 3 months imprisonment in hard labor imposed on the appellant by the court below. 2, or B, the appellant is further sentenced to 12 calendar months imprisonment in hard labor on count 2, that is the defrauding by false pretenses, and count 3, also defrauding by false pretenses from the date of conviction, that is the 3rd of July. So this now explains, right? So if this holds effectively, what is going to happen is that the 7 months Agradaa has been in custody already would be deducted from the 12. So effectively, we're seeing just about 5 months left. The appellant is further sentenced to a fine of 200 penalty units on counts 2 and 3, that's the defrauding by false pretenses. In default, her payment of the fine, she is to serve an additional term of 1 year imprisonment in hard labor. All the sentences mentioned, A, B, and C, are to run concurrently and with retrospective effect from the date of her conviction. It goes on and on. But there's something that we want you to pay attention to quite closely regarding this, that the appellant has been ordered to refund the amount, and that there is no defined minimum sentence of imprisonment imposed by law. And this is where we take you to what the position of the law is on this matter. And take a look at this. A person who defrauds any other person by a false pretense commits a second-degree felony. Second-degree felony. And it continues. A person who by means of a false pretense or by personation obtains or attempts to obtain the consent of any other person to part with or transfer the ownership of a thing by false representation of acting in accordance with the instructions, orders, or requests of the president or member of the cabinet. It goes on and on. But the emphasis here, this involves the using the president's name and or a member of cabinet to defraud someone. And we've seen this happen a number of times. Agradaa doesn't fall in this category. So this is where Agradaa falls in this category. A person who defrauds any other person by a false pretense commits a second-degree felony. So what exactly does the law say when it comes to the sentencing guidelines as to how many years any person who is charged with defrauding by false pretenses will be slapped with? And then we would understand what the trial judge talks about, the minimum number of years. This is the general rules for punishment. And this is in section 296 of Act 30. Where a criminal offense which is not an offense mentioned in subsection 5 is declared by an enactment to be a second-degree felony, and the punishment for that offense is not specified, a person convicted of that offense is liable to a term of imprisonment not exceeding 10 years. Not exceeding 10 years. So if you look at the wording of this, section 296, and what the trial judge says, you know what? There's no defined minimum term for any person charged with this particular offense of defrauding by false pretenses. Then you juxtapose that with this. Now, it says where a criminal offense which is not an offense mentioned in subsection 5 is declared by an enactment to be a second-degree felony, and the punishment for that offense is not specified, a person convicted of that offense is liable to a term of imprisonment not exceeding 10 years. But here's the catch. What it means is ordinarily, defrauding by false pretenses shouldn't be, the person who is charged with that should not be punished more than 10 years. But there's an exception to this, and this is what you find in here. A person convicted of a criminal offense under any of the following sections of the Criminal Offences Act 1960, that is to say 124, 128, 131, and the emphasis here is on 131. 131 is on defrauding by false pretenses. Is liable to a term of imprisonment not exceeding 25 years. So, what this technically means or legally means is that when you're charged with defrauding by false pretenses, you can be sentenced to up to 25 years, even though for second-degree felonies, it's 10 years. So there's an exception to what we have seen here. And you can find all of these explanations that we've just showed to you. It's embedded in the law, specifically the Procedure Act, that's Act that's 1960, Act 30. Martin Pebo is private legal practitioner, is connected with us on Zoom right now. We're hoping to get a clear connection to him, and then we'll put matters in context. Martin Pebo, good evening. Hello, Council, can you hear us?
Yes, good evening.
Perfect, thank you. Thank you so much for joining us this evening. Now, I've sought to just lay some foundation to the conversation this morning, referencing what the position of the law is and teasing out what the trial judge took into consideration. The point that the trial judge makes in this appeal matter is that to the extent that there is no minimum sentencing for this particular offense of defrauding by false pretenses, then there had to be that the judge applying his own discretion in this matter in this 1 year that we have seen. How does all of this play out for you, especially taking into consideration the concerns and the reactions that the public have made to this decision of 15 years down to 12 months? And effectively, the 12 months, the 7 months that she's been in already will be deducted from the 12 months, and she's going to be in for 5 months.
Right. So the judge is right, okay? A number of reasons. Yes, the judge, Justice Solomon Chumesi, right? Yeah, made the point that, yes, there is really no minimum. So the sentence varies from a fine. So it could even have been a fine. So it moves from a fine up to a maximum of 25 years. Correct. Good. Now, the reason we can justify the sentence is that amongst one of them, let's go to some of the previous cases of the courts. Look at Salome's case, Victor Salome. You see that the judge referred to that case where we lost $1,900,000. You see the court computerization project, etc. That's a case involving Victor Salome, who was a deputy minister for finance. Yes, we lost $1,900,000. And yet in that one, Salome was given 8 years. 8 years. This Agradaa case, in total, the sums that he's defrauded the people of is about 1,000 Ghana cedis. Yes, Mr. Okanse, you heard me right.
Yes.
Yes, 1,000 Ghana cedis. Or for those who like, and I like the way Justice Solomon Chumesi upon made it clear that for those who like the old currency, so you will say 1,000 is how much? 10,000 in the old.
Ghana cedis, yes. 10,000 cedis.
Okay, but it's 1,000. Please, you heard me right. One of them was 540 Ghana, then the other one 400 something. So 1,000 Ghana was what was involved, and yet Agradaa was sentenced to go and spend 15 years. You see, Justice Chumesi upon quoted President Kufuor making the saying that it was like killing a mosquito with a sledgehammer. You know, I have my differences with President Kufuor, but today is not one of those days. Today, he's been quoted positively. So let's go with that positive quotation. That he thinks President Kufuor's saying that a mosquito is being killed with a sledgehammer comes in handy. And so, yes, all in all, I think that Justice Chumesi Opong has made the right decision, so that having defrauded somebody of 1,000, two people of 1,000 Ghana cedis, 12 months in custody, it's okay. And let's not forget that Agradaa remains a convict. So today, if Agradaa goes to the American embassy seeking a visa, when she fills in that form, there's a column where they'll ask her, has she been convicted of a felony? She has to put in yes. And that drastically reduces her chances of getting a visa. Most of the developed countries, yes, you answer. Are you a convicted felon? Agradaa is one. And so it's going to be an inconvenience she will suffer for a long time to come, unless maybe she wants to appeal again to the Court of Appeal to see what can be done. But for now, with the verdict, she remains a convict. And it comes with grave consequences. Yeah, grave consequences. So for those thinking it's a slap on the wrist, I don't agree. The figure involved is 1,000. Let's also make the point that there were other persons who said they pay 4,000, etc. But those persons did not come forward to testify. Yes, another person said he had been duped of 4,000, but he didn't testify. So the court cannot use that. The ones who testified are those who paid 540 and the 400 something, making together about 1,000 Ghana cedis. So Agradaa is serving a jail term now of 12 months because of the 1,000 Ghana cedis, and also because of making the charlatanic adverts. Yes, so you make adverts where you say you can do miracles, you will do certain things when you know you cannot do them or you would not. So these are the things that the judge looked at. And also, yes, so you look at the cases involving Aquina versus the Republic, look at Abu Gapele and co. You see, we lost more money. Abu Gapele's sentence was 6 years, right? Causing financial loss.
Yes.
For 6 years. right, etc. A lot of the time, we are not, please, I'm putting this in context, so I'm not justifying anything. I'm just a lawyer, an analyst, citing other cases. Please, these are not personal opinions. These are cases. So I'm saying that the Abuga Pele case, Abuga Pele got 6 years, right? When we lost hundreds of thousands of dollars, okay? And then you look at the other cases that have got a lot of cases where we've lost this and a lot of money, okay? And their sentences were far lesser than the 15 years that was handed Agradaa, which looked grossly disproportionate. It stuck out like a sore thumb. So it's okay that the trial judge has straightened it so that it's no longer sticking out like that.
I see. But the trial judge also did acknowledge that the 15 years has had an element of deterrence in there, which he also acknowledges. In fact, he cites with the fact that the 15 years then was supposed to send a signal to all other persons involved in this charlatanic behavior that they would have their day in court if they don't take care. And so if that was considered with this 1 year, how's that going to work? How deterrent will this be?
Yes, so I keep saying that, you see, the deterrence principle, you see, when it comes to sentencing rules, so it comes to the theories of punishment, right? We have those that, the utilitarian principles, okay, so in one of them you hear that you punish so that it will lead to the greatest good of the greatest majority of the citizens, okay? You hear the restitution theories, okay? Then this eye for an eye, okay? So you punish or you sentence the person to punish for what they also have done wrong. So that's when you hear an eye for an eye. But you also hear that an eye for an eye, that's saying when you do the complete, if you do the complete saying, it says that an eye for an eye would make the world go blind. That's the full meaning. But every time you hear an eye for an eye, no, its full rendition is that an eye for an eye would make the world go blind, right? Yeah, so that's to say that all in all, we look to the restitution, okay, the theories that ensure that there's restitution, okay? You don't just want to do utilitarianism or the other one. So that's the eye for an eye, just inflicting punishment. They will tell you that Professor Mensah will tell you that the accused person deserved his just desserts. Yeah, the accused person deserved his just desserts. In this case, the just desserts that Agradaa deserved was that she took 1,000 Ghana cedis and she's going to do 12 months. I think it's proportionate. You see, the trial judge also referred to other cases. Even there's another Supreme Court case, Banahini versus the Republic. In that case, the Banahini refunded, a lot of the stolen money was recovered, etc. So the Supreme Court drastically reduced the sentence. So please, what listeners and watchers need to go away with is that at the heart of this matter, Agradaa took 1,000 Ghana cedis. That is what was proven. It doesn't matter that another person said he paid 4,000, and then there was a fourth person who also mentioned there's a certain figure, I don't have it. But those two other persons didn't come forward.
I see. So if these two come forward to testify, that will be treated as a fresh case, or what? Would it amount to double jeopardy?
Excellent. It's too late. They belonged in this category. That's a case that was tried. So once they didn't come up to testify, that's a closed book. It's too late. We cannot start another trial. So nobody is supporting what Agradaa did. No. Far from it. As I said, we are going by the decided cases. You see, the jurisprudence. Nobody is supporting it. I'm sure she herself, she's learned a great lesson. And it's just like Mr. Okan said, when we're doing the abolition of the death penalty, we're met with similar arguments. No. If you abolish the death penalty, it will lead to an astronomical increase in murders, etc. Today, I'm not sure that is the story. So as we are making progress in life, we also look to, improve the sentencing regime. What we need to do, actually, we don't have good laws on sentencing. You look at the UK, the US, etc. Even the US, they have a sentencing commission. Sentencing, so specialists in sentencing, then they come up with laws on sentencing. In the UK, you see the sentencing rules, fat books, very big. Ghana, we did a sentencing guideline when President Mahama was president, the 2012 to 2016 regime. It didn't go far because it remained a guideline. We didn't make it into hard law, such as a CI or an LI. So in actual fact, you will see many lawyers who will tell you they've never even seen it. And it doesn't, the judges, a lot of them don't feel bound because we didn't make it into hard law. So definitely we need to improve our laws on sentencing. We are 100 or more years behind.
I see. Well, Counsel, maybe quickly and finally, to the extent that she's a second-time offender of a similar offense where she was actually fined, does it not come into consideration in for instance, determining this sentencing for that matter?
It does if prosecution was pushing it hard. But as I said, the overriding principle in this case is that it's the 1,000 Ghana that was at stake. And for 1,000 Ghana, let's look at it again. It was 1,000 Ghana that was at stake. So that goes way, it counts a lot more than the other things like she said, second-time offender, etc. It's 1,000 Ghana that she took.
Right.
Yes.
So I do appreciate your time, but there's probably something that we're just getting right now, which will be of interest to you. But we're going to go for this quick break. There's some news coming in on Sedina Tamakloe from the United States.
I'll be watching.
Perfect.
I'll be watching.
Perfect.
Thank
We're going to go for this quick break. Stay with us. We'll be right back with that exclusive, the breaking news coming through right now. Stay with us. Welcome back. This is Ghana Tonight, and this, as you saw there, that breaking news coming through and the indication I gave to you. The U.S. Marshals Service has provided a blow-by-blow account of the arrest and detention of Miss Sedina Tamakloe Ationu. And this we've been following quite closely. Sedina Tamakloe Ationu, the former CEO of the Microfinance and Small Loans Center, MASLOC, had fled, and I'm reading this based on information that we've gotten from our sources on this particular matter, fled to the U.S. before the High Court trying her, convicted and sentenced her to 10 years imprisonment. We do know this is public knowledge. In April 2024, for causing financial loss to the state, stealing, conspiracy to steal, money laundering, and violating the Public Procurement Act. January 15 this year, Ghana's ambassador to the United States, Victor Smith, if you recall, has stated that Ms. Sedina Tamakloe Ationu was arrested by the U.S. Marshal Service and was being held at the Henderson Detention Center in Nevada. He provided no further details, and we had cause to ask more questions as to exactly what was going to happen after that said date of January 6th that we got to know. In fact, later we found out from the ambassador, and we did establish that indeed Sedina Tamakloe and Ken Ofori-Atta were picked up on the same day by different state agencies. So ICE picked up Ken Ofori-Atta, the U.S. Marshals picked up Sedina Tamakloe on the same day. Now, this is the account, the blow-by-blow account by the U.S. Marshals Service. The arrest and the location on the 12th of December 2025, a warrant of arrest for Sedina Tamakloe was issued on the 12th of December 2025 in the United States District Court for the District of Nevada for being a fugitive from the Republic of Ghana, pursuant to conviction of embezzlement-related charges, which sought her extradition. On the 12th of December 2025, Deputy United States Marshal, and we got this part redacted as was assigned to the case. On the 1st of January 2026, members of the Nevada Violent Offenders Task Force. So take note of this. On the 6th of January 2026, members of the Nevada Violent Offenders Task Force at approximately 12:15 p.m. moved in, and at approximately 2:30 p.m., Sedina Tamakloe Ationu was positively identified, opening her front door and then closing it, returning into her residence. At approximately 3:05, that's 15:05 hours, the Nevada force that's on approached the residence to execute the arrest warrant. A knock and announce was conducted and contact was made with Sedina Tamakloe Ationu at the front door when she opened it. Sedina Tamakloe Ationu was placed in restraints and searched on scene before being placed in the back seat of the task force officer, that's a TFO. Continues that Sedina Tamakloe Ationu was transported by the task force officer, followed by the other members of the unit, to the federal courthouse located at 333 Las Vegas BLV NV 89101. That's the address of that said location. The District of Nevada unit and also other forces personnel then transported Sedina Tamakloe Ationu to Henderson Detention Center, located at 18E Basic Road, Henderson, Nevada, 89015, a U.S. Marshal contracted holding facility where Tamakloe Ationu was held overnight. On the 7th of January, the next day, Henderson Police Department transported Sedina Tamakloe to the federal courthouse at approximately 8:30 a.m., where she was booked into the U.S. Marshal's custody. So this is what so far sources close to this, as we do know, have put out, and this was giving us a request for information pursuant to the Freedom of Information Act in the United States by William Nyako. So that is what we got to know right now. This is the information coming through right now, a blow-by-blow account of what happened in the arrest of Sedina Tamakloe. And as we do know, she was to also be arraigned before court on the 21st. But as of now, we don't have so much of an update. But at least now we know how she was arrested and what happened afterwards. Counsel.
Yeah, that's illuminating, very illuminating. It's good, sunshine is the greatest disinfectant. So it's good that the marshals have given us this blow-by-blow account. It helps to open our eyes to see how the process works. So ultimately, we are waiting for her extradition to Ghana. But before then, I had said it previously, and it's good to repeat. Look, Sedinam should just agree to deport, to come back to Ghana quickly, to start serving the prison term. Because if she drags her feet and then she's eventually brought here, she would have no sympathies. Yeah, she would have no sympathies. The writing clearly on the wall is that she should have come back as soon as the NDC won, so that at least that will help to, reduce the blame that the NDC will be subjected to, etc. Remember, as the government was going after Oforiatta, and then those of us who kept talking about Oforiatta, you see on Facebook, etc., people who are people of the other persuasion came at us that you're not talking about Sedinam. You're not talking about Sedinam. So that tells you that the more she stays away and so she would have to be dragged in, it would give this government a bad name, and the NDC for that matter. So she should look at the integrity of her party, etc., and come back home quickly, just as we've said the same thing against Oforiatta. So it applies to Sedinam. She's causing embarrassment to the government and to the NDC for that matter. So she should look at the bigger picture and calm down.
Counsel, appreciate your time on this. We'll see if that advice will be taken, because you on the same principle, you extended the same advice to Ken Oforiatta, is it not? That his continuous stay is impacting on the NPP negatively from where you sit, right?
Absolutely. So the same for Sedina.
Thank you.
Yeah. You're welcome.
Martin Pebbles, private legal practitioner. On behalf of the team, we do appreciate your company. Thank you for staying with us here on Ghana Tonight. We're back again tomorrow, but join the New Day team tomorrow morning on TV3 and also on Sunrise 3FM 92.7. Mawena Eric Egbeta, together with Johnny Hughes, is back. And there's more on 3news.com. Have a good night.
Ghana Tonight is brought to you by
Flamingo Paint, superior durability, superior hiding.